Welcome to Chapter 7, Negligence and Strict Liability. When someone's person or property is hurt, how far should society extend liability? The law has struggled for centuries to find compensation for the injured without making every citizen the insurer of all others. Oliver Wendell Holmes said that the life of the law has not been logic, it's been experience. In order for a plaintiff to win a negligence case, they must prove that the defendant failed in 5 areas. The defendant must have failed in the duty of due care. There must be a duty owed to the plaintiff. There must be a breach, and this duty must be breached. There must be factual cause. The injury must have been caused by the defendant's actions. There has to be foreseeable harm. It must have been foreseeable that the action would cause this kind of harm. And of course, there must be injury. The plaintiff must have been hurt. If a defendant could have foreseen injury to another person, she has a duty to him. In some states, a social host serving alcohol to an adult may be found liable for harm by the person drinking the alcohol. Many states have dram shop laws, making liquor stores, bars, and restaurants liable for serving drinks to intoxicated customers who later cause harm. As stated in the Affirmative Duty to Act, in general, the common law does not require a bystander to assist a person in danger. Hernandez versus the Arizona Board of Regents is a case of duty of due care. The University of Arizona chapter of Delta Tau Delta fraternity gave a welcoming party for new members. The fraternity's officers knew that the majority of its members were under the legal drinking age, but permitted everyone to drink alcohol. Minor John Rayner left the party, drove negligently, and caused a collision with the car driven by Ruben Hernandez. Rayner's blood alcohol level was 0.15, exceeding the legal limit. The crash left Hernandez blind, severely brain damaged, and quadriplegic. Hernandez sued Rayner, who settled the case. Hernandez also sued the fraternity, its officers, and national organization, all fraternity members who contributed money to buy alcohol. The trial court granted summary judgment for all defendants, and the Court of Appeals affirmed. Hernandez appealed to the Arizona Supreme Court. The issue is this: did the fraternity and the other defendants have a duty of due care to Hernandez? Judgment for defendants reversed, and the case remanded for trial. The court's opinion stated the following: traditional authority held that when an able-bodied man caused harm because of his intoxication, the act from which a liability arose was consuming, not furnishing the alcohol. However, the common law also provides that one who supplies something for the use of another, whom the supplier knows or has reason to know to be likely because of his youth, inexperience, or otherwise, to use it in a manner involving unreasonable risk or physical harm to himself and others, is subject to liability for physical harm resulting to them. A growing number of cases have recognized that one of the very hazards that makes it negligent to furnish liquor to a minor is the foreseeable prospect that the young person will become drunk and injure himself or others. Accordingly, modern authority has increasingly recognized that one who gives alcohol to a minor breaches a common law duty owed to innocent third parties who may be injured. We join the majority of other states and conclude that as to plaintiffs and the public in general, defendants had a duty of care to avoid furnishing alcohol to underage consumers. Arizona courts, therefore, will entertain an action for damages against one who negligently furnishes alcohol to those under the legal drinking age when the act is a cause of injury to a third person. The lower courts found for the defendants. Why do you think this was? Well, presumably, they found that the defendants had no duty to Hernandez or the general public. They would both have found that Rayner, the driver, had a duty, but not someone who bought him alcohol. What is the logic behind the lower court's position that a person or organization that gives someone liquor has no duty to the general public? Well, historically, courts have held that it is a drunk driver who brought the harm on himself and others by getting drunk in the first place, and that injured parties could look only to the driver for compensation. Courts often held that a host, whether a social host or an organizational host like a bar or fraternity, could not foresee the harm, or, as a matter of public policy, should not be liable for such harm because extending such liability that far would inhibit social events and would create an almost endless field of potential liability. If victims of criminal attacks are unable to obtain compensation from the perpetrator of the assault, they are now likely to sue the owner of the premises where the crime occurred. Landowners have a duty to not injure trespassers intentionally. A landowner may be liable if a man-made item on the land attracts children and a child is harmed. They should also warn of known but hidden dangerous conditions licensees are unlikely to discover for themselves. Lastly, landowners should protect people who they invite onto the property against dangerous conditions that a reasonable person would be unlikely to discover on his own. A defendant breaches his duty of due care if they fail to behave the way a reasonable person would under similar circumstances. Courts have found companies liable for hiring and retaining employees known to be violent when those employees later injure coworkers. Negligence per se refers to when legislatures set a minimum standard for certain groups of people, especially children, and when a violation of that statute hurts a member of this group, the duty is breached. Factual cause means that if what the defendant does ultimately led to the injury of someone else, he is liable. He may not have been responsible for the immediate cause of injury, but the act must be the first in the direct line. Foreseeable harm means that to be liable, the harm must have been foreseeable. The defendant does not have to know exactly what would happen, just the type of event. In some cases, the defendant must prove that he was not negligent, or the facts imply that his negligence caused the injury. For a plaintiff to win, he or she must show genuine injury. Future injury may also be compensated, but this must be determined at the time of trial. A bystander, even if she is unharmed physically, may recover for emotional distress if she was near the scene of the injury and this caused her immediate shock because she was a close relative of the victim. Damages are usually compensatory. This means that they are designed to restore what was lost. In unusual cases, they may be punitive. In a few states, if the plaintiff is at all negligent, he cannot recover damages from the defendant. This is referred to as contributory negligence. In most states, however, if the plaintiff is negligent, a percentage of negligence is applied to both the defendant and the plaintiff. This is referred to as comparative negligence. The plaintiff can recover from the defendant to the percentage that the defendant is negligent. In some cases, a plaintiff found to be more than 50% negligent cannot recover at all. If a person voluntarily enters a situation that is obviously dangerous, she cannot complain if she's injured. This rule applies to a situation where the danger is well known and the person chooses to be there. Some activities are so dangerous that the law imposes a high burden on them, which is called strict liability. For example, defective products like toys that are unsafe for children to play with may incur strict liability. When activities are ultra-hazardous, defendants are almost always held liable for harm if they're involved. This includes using harmful chemicals, explosives, and keeping wild animals. The plaintiff does not have to prove breach of duty or foreseeable harm. Comparative negligence does not apply here. The defendant engaging in the ultra-hazardous activity is wholly liable. The next time you're out and about, try to find a negligence suit waiting to happen. Try to find some careless maintenance, unsafe condition, or other unreasonable behavior that's inviting a problem. Are the university stairs in satisfactory shape? Are the doors in your apartment secured with a lock and is visitor access controlled with an intercom system? Are sidewalks shoveled free of snow when you leave? Does your employer maintain a safe workplace? At a construction site, are pedestrians exposed to any dangers? You should be able to find several instances of unreasonable behavior. You've probably heard about the lawsuit in which Stella Liebeck sued McDonald's for burns she suffered after spilling a cup of its takeout coffee in her lap. But I'll bet that whatever you know about the case is either wrong or incomplete. You may have also seen a chain of emails about the Stella Awards, named after Liebeck. Its message is that the tort system is out of control. Whatever problems exist with the tort system are not revealed by the stories in the Stella Awards email because none of the stories are true. All are urban legends and they've been circulating online for years. As for Liebeck's suit against McDonald's, what most people don't realize is that the coffee that burned her was 180 degrees, 20 degrees hotter than coffee typically served in restaurants. The jury considered whether McDonald's acted improperly in selling 180-degree coffee, which was significantly hotter than a consumer would expect from their common experience. Stella Liebeck incurred third-degree burns, received skin grafts, and spent 7 days in the hospital. Testimonies at trial showed that before the lawsuit, McDonald's had received over 700 complaints about burns, some of them third degree, suffered by customers who spilled coffee on themselves. A McDonald's executive testified that McDonald's knew of the risk of burns caused by its hotter-than-average coffee and knew that most customers didn't realize the specific risk posed by coffee at those temperatures, but nevertheless didn't intend to warn customers of the risk. The suit was not about a mere failure to warn that coffee is hot. It was about the failure to warn about the danger created by serving materially hotter than normal coffee to customers who knew they were buying something hot, but not that hot. With any case, it's important to really think about the concept of duty of due care, and we should also take the time to learn the facts before passing judgment. While many lawsuits are completely warranted, there's a good case that many are not justified and the price paid is far too high. In March of 2006, Tillinghast, a consulting unit, issued a report that put the annual cost of the American tort system at $260 billion, almost equal to the annual sales at Walmart.